Para for dictation, 5 seconds to start. 5, 4, 3, 2, 1. The present appeal was contested by learned advocate appeared on behalf of the respondent number 2 insurance company full point. At the outset, learned advocate has invited my attention to the reasons assigned by the tribunal and has submitted that the tribunal, upon appreciation of the evidence of the claimant as against the evidence of the investigating officer and the A summary report, which has emerged on record, has rightly shifted the burden upon the claimant to prove his case beyond reasonable doubt. Full point para. Learned advocate has further submitted that the FIR in question with regard to the accident and the Panchnama of the place of accident loses its significance once the A summary report was filed by the investigating officer at the end of the investigation. Full point. Learned advocate has further submitted that the original claimant has not challenged the A summary report filed by the investigating officer and no re-investigation has been sought for by the original claimant. Full point. While drawing attention of this court to the documentary evidence relied upon by the original claimant, she has submitted that the said documents have not been admitted as evidence by the tribunal. Full point. Hence, there is no corroboration to the oral evidence of the original claimant, and in absence of any evidence being brought on record as against the discrepancies noted by the tribunal, no error can be found with the approach of the tribunal in dismissing the claim petition. Full point para. Learned advocate for the insurance company has further submitted that no material evidence has come on record to establish the fact of earning of the original claimant at the time of the accident. Full point. So far as the disability incurred by the original claimant due to accident is concerned, the same has not been proved by examining any doctor by the original claimant. Full point. Learned advocate for the insurance company has vehemently submitted before the court that once the tribunal had arrived at a conclusion that the claimant had failed to prove his case, more particularly, about the involvement of the vehicle as alleged in the claim petition, the tribunal ought to have taken note of such fact of filing dubious case by the original claimant. Full point. Against the aforesaid submissions, this court had called upon the learned advocate for the insurance company to verify as to whether any application was tendered before the tribunal or any complaint was lodged before the concerned police station, to which learned advocate was unable to assist the court. Full point.